Cobleys is a firm that's been specialising in criminal law for 30 years now at the very highest end. We were noticing, particularly in recent times, how investigating authorities were becoming more and more lax with regard to the legality and formality that they had to and must follow in relation to search warrants, thereafter arresting people and also detaining them. We saw that this was a very niche area and also that nobody else was offering this service, and we knew that we had the experience and we had the knowledge, and therefore the department was set up. Anybody can read a law book, but there's no substitutes for experience, and the best experience is gamekeeper turned poacher. So our specialist team is made up of lawyers, but also very high-ranking police officers who know absolutely everything that there needs to know about the process of applying and executing a search warrant. So they are the very best people to go to find out whether the investigating authority has conducted themselves properly.
Challenges to search and seizure are brought in the High Court by way of judicial review. Now obviously search and seizure operations are part of a criminal investigation, but they're not part of a criminal case. And as a result, most criminal lawyers don't even think to challenge the search and seizure operation which occurs at the beginning. And if they do think to do it, they often don't know how to go about it.
When someone comes to Cobleys, our team will consider the merits of that case. On occasions, sometimes a case will not have any merit and the client is told immediately, thereby avoiding any unnecessary costs. However, if the case does have merit, we then instruct counsel, be it junior counsel or Queen's counsel, which is all dependent upon the complexity of the case.
What can be achieved in any given case depends ultimately on its strength, and that will vary. But it also depends on what the particular client wants to achieve from bringing that case. Some may feel obligated to bring it because they hold confidential documents that have been taken, confidential to some other person, perhaps an employee or a client of their own. Others may wish to halt a criminal investigation. Sometimes that's possible. But others still may feel aggrieved by the fact that the operation has taken place at all, and they may wish to vindicate their rights and seek compensation. As I've said, if a claim is to be brought to challenge a search warrant, it's brought in the High Court. But the procedure once the claim is issued is that the papers will be considered by a single judge of the High Court who will decide whether it's arguable or not. Assuming that he or she decides that it is arguable, it will go forward to a full hearing, and that'll take place before two judges. If the claim is successful, they'll consider what relief to give to the claimant, and that can include the return of all the documents or items seized, and also awarding damages.
Every client will want to know, and indeed is entitled to know, how much their case will cost. Depends upon the complexity of the case, the cost will vary. But our experience allows us to be able to keep the client informed. We structure our costs. We only issue if we think that the case has merits and we can succeed. And obviously, if we succeed, the other party has to pay the costs.